here, and the first one, according to my count, we have 14 persons wishing to testify and want to make sure that they each have equal time. So I'm going to, given our time constraints, going to have to limit everyone's testimony to 3 minutes. So when there is 1 minute remaining, if you'll, as you give your testimony, I will hold up a folder, and the folder indicates 1 minute remaining. So be sure to start wrapping up your thoughts. And we wish we could allow unlimited time for everyone, but we have time constraints for other committees for today and every day. So with that then, I want to welcome everyone again and open the hearing on Senate Bill 288, prohibiting certain sex offenders from entering onto school property or attending school activities and creating criminal penalties for violation thereof. And with that, a bill brief from the reviser.
Thank you, Madam Chair. Senate Bill 288 makes some changes in the Kansas Offender Registration Act. The first section would be a new section of law to provide that it would be unlawful for any sex offender who is 18 years of age or older, whose underlying crime for which they're required to register was a crime against a victim who is less than 18 years of age, to enter onto school property or attend a school activity. On a first conviction, violation of this section would be a severity level 6 person felony. On a second conviction, it would be a severity level 5 person felony. And on a third or subsequent conviction, it would be a severity level 3 person felony. Section 2 amends KSA 224901. This is just the statute that cites the act, essentially just to include this new Section 1 in the Kansas Offender Registration Act. And finally, Section 3 amends KSA 224902. This is the statute that provides for the definitions that are used throughout the Offender Registration Act. And this section is amended to include definitions of what a school activity and school property are. And I can take any questions.
Thank you. Committee, any questions for the reviser? Not seeing any, then we will go ahead and get started. Thank you very much, Ms. Scott. And these proponent conferees are in no particular order, but we will go ahead and start with Steve Howe, Johnson County District Attorney, Kansas Association of Kansas County and District Attorneys Association. And with that, please introduce yourself and welcome to committee.
Thank you, Madam Chair and members of this committee. My name is Steve Howe, Johnson County District Attorney. The situation that brought on this bill came from my jurisdiction. And I think credit goes to our chair for finding this hole in the statute and saying we need to do something about it in order to protect our kids. It is clear from the evidence and the studies that have been out there that individuals who prey on children have a high recidivism rate. I cited in my testimony both my experience on the Saki initiative, where we tested all the untested kits in Kansas, and what we determined, which I think is pretty compelling, is that those individuals, once we identified them, had created a large swath of destruction in our communities, either in violent crimes or other sexual assaults. And so that also is consistent with the national studies that indicate that these individuals do have a reoffending rate higher than other individuals in the other categories. The reason why we're asking to do this is basically consistent with what some of the other steps that this legislature has taken. The Registration Act, where this would be put into. Also, the sexual predator section of our state hospital, where individuals who are considered high risk to reoffend in our community have to go through a civil commitment proceeding. So this legislature has taken steps to protect children. This is clearly a hole that needs to be filled. It's not a partisan matter. It's more of a public safety issue. To me, it seems like individuals on both sides of the aisle would be able to get behind this bill because it is about the children and protection of the children. And we know that the individuals like this, as specified under the bill, are high risk to reoffend, and in interjecting them into a school function not only puts them in the risk of reoffending, but also puts our children at risk. And so I know we're on limits on time. I think my testimony that I've submitted in writing outlines the reasons why I support this bill, and I would ask this committee to pass it out. It's a common sense bill for public safety, and thank you for your time.
Thank you. And if you have time, can we hold questions until we have all the conferees?
Yes, I am available for questions after you're done with all the conferees.
Great, thank you. Then we are going to hold questions from committee until we've had all the proponent conferees have an opportunity to testify. Next, we will hear from Ed Klump on behalf of the Kansas Sheriff's Association, the Kansas Association of Chiefs of Police, and the Kansas Peace Officers Association. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. I am Ed Klump, and I'm here today representing the Kansas Association, Chiefs of Police, Kansas Sheriff's Association, and the Kansas Peace Officers Association. We are honored to stand as a proponent of this bill. We think this is an area that needs addressed. Interestingly enough, a couple of House members came up to me a couple of weeks ago and brought this same topic up. And so it's something that's being thought of and other people are noting right now. I'll also mention before I forget to that over the course of the last few months, we've had several of our members come to us and talk about this particular issue of registered sex offenders on school grounds. And so this is very appropriate timing for us. This bill is very well written in our opinion. It's narrow in scope as it should be. Yet it covers all of the people that we should be very concerned with in the school environment. Does it in a very even-handed manner, in our opinion. The age restrictions and everything are very appropriate for that. The one thing when the House came to me that I noticed right off the bat is they wanted to use the term school, and I noticed that the definition in the existing statute for school would not work well in this setting at all. So in this bill, it refers to school property, then defines school property, and that makes this bill work extremely well. I just want to stress how important that provision is and that reference to school property rather than school by itself, because that has a whole different meaning throughout the Offender Registration Act. And Madam Chair, I just thank you for bringing this bill forward, and we're proud to be a proponent for it, and we'll stand for questions at the appropriate time.
Thank you. Next, we will hear from Casey Dalkey, Executive Director, Children's Advocacy Centers of Kansas. Please introduce yourself and welcome to committee.
Thank you, and good morning, Madam Chair, members of the committee. My name is Casey Dalkey, Executive Director for Children's Advocacy Centers of Kansas, a network of 18 child advocacy centers across the state, and we provide a coordinated approach to child abuse investigations. As you could imagine, what we see at the Child Advocacy Center, the cases that are referred or when we are activated, unfortunately an offense has already taken place. And that is why we are thrilled to see and express our strong support and proponent of Senate Bill 288. This is a common sense safety measure protecting Kansas kids, and we are happy to stand here today in support of. Throughout my testimony that you have received, you're going to see some key points that I would like to touch on, just a few of them while I'm up here today. And starting with the first, schools should be a safe place for children to go, to learn, to grow, and evolve. Research shows that children who have experienced sexual abuse specifically oftentimes struggle with PTSD, anxiety, and depression. Those diagnoses can be exacerbated when exposure to offenders takes place. Senate Bill 288 prevents re-traumatization or traumatization in the first place, and ensuring that children are not forced to confront offenders in school settings where they are meant to learn. Protecting children from repeat offenders, research consistently shows that individuals convicted of sex crimes against minors have a heightened risk of reoffending. I have some research outlined for you in my testimony, but particularly in high-risk settings, which would be a school setting and further exposure to minors. There's a 15-year study conducted by the U.S. Department of Justice. The recidivism rate for offenders, sex offenders with minors is 23%. And so oftentimes offenders have connections to their victims, whether that is a family member, a family friend, a teacher, a coach, or a para. And last year, our centers saw that at 97% of children knew their offender. So we feel very strongly about Senate Bill 288. It's a necessary evidence-based step to protect Kansas kids, and this bill creates safer schools, prevents reoffense, and gives law enforcement in schools the tools they need to protect children. I urge this committee to pass Senate Bill 288 to ensure that Kansas remains a leader in child protection and crime prevention. CACs of Kansas is ready to collaborate with legislators, law enforcement, schools, and implement best practices and work on this bill as needed. With that, I will stand for questions at the appropriate time.
Thank you. Appreciate it. Next, we will hear from Judy Rodman, CEO, Sunflower House Child Advocacy Center. Please introduce yourself and welcome to committee.
Good morning, Madam Chair and committee. Thank you for allowing me to be here today. I'm Judy Rodman, President and CEO of Sunflower House Child Advocacy Center. And so we serve Johnson and Wyandotte counties. And so I am here today. I want to talk about a collaboration that we have done. Not only, as Casey just explained, child advocacy centers serve kids that have experienced abuse, we also work on prevention efforts. And so Sunflower House has worked very hard to sign memorandums of understanding with all of our public schools in Johnson and Wyandotte County to provide necessary prevention education to students from preschool all the way up to high school. So it's very safe. We have a play that we do with our kids, our preschool kids, called Happy Bear. And Happy Bear teaches the kids that no one should touch, look at, or take pictures of anywhere their swimsuit covers. And if that happens, who are the safe people that you could talk to? And so we're very happy that our school districts have joined in and allowing us to come in and provide this education, because so many of our kids don't even understand that what is happening to them is wrong. Because 90% of the kids either know, like, or love their alleged perpetrator. So I want to talk about the occurrences real quick. So 1 in 10 kids will experience child sexual abuse by their 18th birthday. And if we drill that down a little further, it's 1 in 4 girls that will experience child sexual abuse by their 18th birthday. So when we talk about numbers, it's easy just to think about that in a big scope, but I want you to stop and think about the little girls in your life, whether that's your child, your grandchild, your niece, your neighbor. And think about when you're attending one of their soccer games, their dance recitals, their music concerts, and start looking at the little girls in that room. 1, 2, 3, sexual abuse. 1, 2, 3, sexual abuse. And that's the reality of this. Now, I want to say preventing child sexual abuse is possible, but it's the responsibility of the adults to take action and to make sure that our kids are safe. So I just want to share real quick a little bit of my personal background is I'm a licensed professional counselor. So I have provided treatment for victims of abuse, and I've also provided treatment for sex offenders. And I can tell you, sex offenders get to our kids through grooming and manipulative behaviors, and they also do that by grooming and manipulating the adults so they can have access to our kids. So I support this bill. I hope that you will support this bill and be dedicated to keeping our kids safe. Thank you. And I will stand for questions if needed.
Great, thank you. Next, we will invite Christine Antes to the podium, an elementary school parent. Please introduce yourself and welcome to committee.
Hello, I'm Christine Antes, and thank you for hearing me today. As a concerned mom, I am here to urge you to enact clear legislation as modeled on proven state laws and modeled on proven laws in other states to ban registered sex offenders from our school. This hit home when a sex offender attended my son's elementary school dance. This individual, while surrounded by children, was observed using their cell phone camera's application directed toward students on the dance floor. Shockingly, no Kansas law or district policy was broken. Records show the offender pled guilty to distribution or receipt of child pornography via the internet. Per a Fox 4 News report, detectives found hundreds of images, including a 6 to 8-year-old being assaulted. This individual is on the registry for 17 more years, yet free to enter our schools. I've done some research and found states like Arkansas, Missouri, and Florida restrict or ban sex offenders from their schools, but Kansas doesn't. This leaves us exposed. The Kansas Bureau of Investigation shows 12,139 sex offenders statewide. Research, like the DeLisi study at Iowa State, comprised of 216 sex offenders, found that 59% of low-risk offenders, such as child pornography, admit to hands-on crimes, one reporting up to 25 victims. I strongly support Senate Bill 288. There is one piece I would like to address, however. It would allow 18 to 21-year-olds needing education or support service access to schools with defined protocols to protect classmates. I appreciate you drafting this bill and for allowing our schools to be safe and not vulnerable. Thank you for your time and consideration.
Thank you. Next, we will invite Jessica Daubert, a parent, to the podium. Please introduce yourself and welcome to committee.
Good morning. My name is Jessica Daubert. I am also a parent of a Blue Valley School District child at Blue River Elementary. I'm here to testify on behalf of all the children in Kansas. You've already just heard of the incident that happened that kind of brought a lot of attention to parents in Kansas at the fact that a lot of us were not aware that Kansas did not have any laws protecting us from child registered sex offenders. In the incident that occurred last month, we were also very upset to learn that we had no right to go and ask this pedophile to leave the school dance while he was filming and taking photos. He was there with his fiance's daughter, which is not even biologically his. He lives in the backyard of the playground. His backyard faces the school. We were absolutely absurd and shocked at the fact that he is allowed to be so close to children, and these children have no idea what they are walking past every day. I'm angry at the issue when it came about with the principal and the school board, and they also feel like their hands are tied also. So we come to you today and we ask that you make sure that our children are protected when they are in school and when they're around school, and when we are, as parents, are not allowed to be near them to protect them. Protect our vulnerable, and that be the children of the schools. They go to school and we send them to school so that they're safe. We would like to make sure that they are, given that no pedophile or registered sex offender can enter the school and have easy access to them. As a headroom parent in Kansas, I'm only mandated to allow 5 parents in a room for the safety of our children. But a pedophile can roam the school in a dark auditorium with children ages 5 to 10. So this incident has made me question the overall safety of my children at school. And as a parent, we already have to worry about school shootings and allergic reactions to food, bullies, etc. So let's make one less thing to worry about. Let's be one of the many states that has a law to protect us against sex offenders. Thank you.
Thank you. Next, we will hear from Coulter Daubert, a parent as well. Please introduce yourself and welcome to committee.
All right, good morning, and thank you for allowing me the opportunity to come here today. My name is Coulter Daubert. I've also submitted a testimony for what we're here for today, and that's the Senate Bill 288. First off, I'm here on behalf of my beautiful girls, Kira and Bella Daubert, and my son, Owen Daubert, who all attend the Blue Valley School District. I also want to say thank you to all of you for how fast this has turned around. I appreciate you and the work that you do. And I want to say God bless to everybody that has already testified or given their speech. It is awesome to just hear everybody stand up for this and the knowledge that everybody has. I'm here not only as a parent and a father who wants to protect his children on a daily basis, but I am also a youth coach, and I couldn't imagine what I would be feeling if I was to drop my kids off at practice or something like that, knowing that there's a registered sex offender there, and I'm not there to protect them because I do not know. For years, I was born and raised in Southwest Kansas, a small farm community, and I was under the assumption that if a registered sex offender was in the community, that person was not allowed near our school or even to live near our school. And then after living in Florida for 4 years and moving back and this situation coming up and doing some research about it, I found out some of the laws, as others have stated, from other states like Florida. And I do know in my heart, because I am a Kansan, that you all, no matter what party it is, right, left, indifferent, this is something that can be crossed by both parties to protect our children. And that's why I'm here today. And I thank you for your time, and God bless you.
Thank you. Is there anyone else wishing to testify as a proponent in support of the bill? I'm not seeing any, so committee, I want to draw your attention to, we do have at your desk written proponent testimony from me, Senator from District 11, Dr. Tanya Merrigan, Superintendent, Blue Valley Schools, Michael Kage, District Attorney, Shawnee County, and also on behalf of the Kansas Association of Kansas County and District Attorneys, Mark Bennett, District Attorney, Sedgwick County, also on behalf of the Kansas County and District Attorneys Association, Timothy Graham, Director of Government Relations and Legislative Affairs, Kansas NEA, Michelle McCormick, Executive Director, Kansas Coalition Against Sexual and Domestic Violence, Daniel George, a parent, Mary Stang, a private citizen, Gloria Bear, a parent, Karen, and I'm not sure how to say the last name, it's NG, a parent, Jaime Kissinger, a parent, Bradley Mullins, a parent, Ashley DeBruner, a parent, and Elizabeth Newcomer, a parent. Now that we have proponent testimony, I will open it up for questions from the committee. Senator Bowser, and I want to first thank everyone for their testimony and sharing what has occurred in our community. Appreciate you bringing that to our attention. Senator Bowser.
Thank you, Madam Chair. Question for Mr. Howe, please. And I'm like quite a few folks here, I'm surprised we don't already have legislation on the books here. But Mr. Howe, I would assume that if this bill passes, it would apply to homeschooling as well. So if I homeschool my kids, my house is considered school property and any sex offender wouldn't be able to come on my property or into my home. Is that a correct statement? Thank you.
Please go ahead and re-identify yourself so we can keep our record clear. Thank you.
Steve Howe, Johnson County District Attorney. That would be, when you talk about schools, it means any activity by the Unified School District or accredited non-public school at which, for K through 12. So technically, if I was to look at this, I don't think it would cover homeschooling because it's real specific about how it defines a school.
So follow-up question, do you think it should apply to homeschools?
You could do that and cover that situation. I think 99.9% of the cases are going to be covered under the current definition. But if you feel like that would be necessary to prevent individuals who are at home with, then it creates an issue of if you have a relationship with a sex offender who is in a family dynamic with their spouse and has kids, are we going to permit them to have connection or interaction with their own children? And I think that creates a whole difficult issue. And I would suggest that this law, as it's currently constructed, is cleaner. It also doesn't impugn upon the civil liberties of another individual having access to their kids. So I would shy away from that because of those issues.
Thank you. Committee, other questions? Senator Argabright.
Thank you, Madam Chair, and thank you for bringing this to us. I think my question is for Christine. Speaking on 18 to 21 year, I hope I have the right person. Okay. I just want to make sure I understood what you said, and I don't know if that was in reference to an individual education plan reference when you 18 to 21-year-olds. Could you just clarify that piece, please?
Hi, I'm Christine Antis, and I'm a parent at Blue River. So I have a friend who has a son who is autistic, and he receives services through Blue Valley up until 21 years of age. And the way I understand it, those services provide him to work within the parameters of society. So I just wanted to make sure if he was on the offender list or someone with those types of educational parameters would have access to that, if that makes sense.
Madam Chair? Yeah, it does. I think we're thinking about the same track with an IEP student. Yes. Mm-hmm. And I just wanted to make sure we understood what that request was. Thank you.
Yes, thank you so much.
Thank you. Committee, other questions? Senator Haley.
Thank you, Madam Chair, and thank the proponents. I don't know to whom I should frame the question. Along the line of questioning that we've been having, Madam Chair, I guess my concern with this, and whomever wants to respond, who'd like to may, how is there a carve-out, or shouldn't there be a carve-out possible for legitimate interactivity for a parent or guardian or family member who may be beyond the scope of that? I think it was grown out of the time frame that they're going to be of any problem. Shouldn't there be a local control by the school district to allow those with a legitimate interest in their children to be able to? How do we carve out for those cases, or shouldn't there be that? Or maybe the proponents are not the ones to ask at all. I appreciate the intent of this legislation, and I appreciate it being brought as it is. I just have a concern for those who have a legitimate interactive ability there who would be left out as well, Madam Chair.
Thank you, Senator, for the questions. I do know that we do have neutral in-person testimony on behalf of the Kansas Association of School Boards, so perhaps they would be able
I'll hold until that time
to address that. So are there other questions for the conferees, the proponent conferees, that is? So not seeing any. Not seeing any, we will go ahead and invite neutral conferee Shannon Kimball, Government Relations Specialist, Kansas Association of School Boards, to the podium. Please introduce yourself and welcome to committee.
Good morning, Chair Warren and members of the committee. Shannon Kimball. I am the Government Relations Specialist with the Kansas Association of School Boards. We appreciate the opportunity this morning to share our neutral testimony on Senate Bill 288. As you might remember from the last time I was before your committee, we have member-adopted legislative policies that guide our advocacy in the legislature. And with respect to Senate Bill 288, one of those policies that is implicated is the statement around school and safety and security that says KASB supports evidence-based, cost-effective steps to foster safe and secure school environments. This bill is an important component of that. It adds provisions to law that would help us in those efforts, and it does so without creating a structure administratively of unfunded mandates and additional burdens for school districts to manage the process or the prohibition that is set forth in this bill. And so in that regard, we think that is a positive. We appear as neutral on the bill because we also have legislative policy that talks about cautioning the legislature when you put into statute things that may create conflicts for districts in complying with state law and federal law. And in this circumstance, I think there are two things to consider, and it somewhat gets to the question that Senator Haley asked, so I appreciate that observation. One of them is that we do serve 18 to 21-year-old students. We have seniors in high school who turn 18, and some of them 19 during their senior years of high school. We also provide, we are mandated to educate students between the ages of 18 and 21 who are on an IEP, and because of their IEP are entitled to special education services until they either graduate or complete job training or age out of the program. Some districts in Kansas also provide adult education services. Not all of them, but in some districts, they provide diploma completion and adult and GED services on school property, usually separate locations from an elementary school. That would be its own kind of program, but it is on school property. So we just ask the committee to consider those circumstances and leave it to the will of the committee as to how you think we could potentially manage the conflict between that requirement to educate those students and not being able to have a student honor registry on school district property. The second circumstance is related to parents who do have some federal rights, particularly under IDEA, the Federal Special Education Law, to participate in specific aspects of directing the education of their children. And we foresee that there could be tension or circumstances where these two mandates would be in conflict. So again, a situation we ask you to consider as you consider the components of this bill. Appreciate your time. Happy to stand for questions at the appropriate time. Thank you.
Thank you. Is there anyone else wishing to testify as neutral on the bill? Not seeing anyone, then committee, you also have at your desk neutral written only testimony from Susan Willis, Government Liaison and Finance Manager at Wichita Public Schools. And with that, then we will open it up for any questions. Not seeing any, then we will next invite opponent conferee Grace Tran, BIDS Legislative Committee, Kansas State Board of Indigence Defense Services. Please introduce yourself and welcome to committee.
Good morning, Chair Warren and members of the committee. My name is Grace Tran. I'm an attorney at the BIDS Legislative Committee. And the BIDS Legislative Committee stands in opposition to Senate Bill 288 because we believe that it will not decrease recidivism and may, in fact, actually increase it. So the federal government's Department of Justice's Office of Sex Offender Sentencing, Monitoring, Apprehending, Registering, and Tracking, also known as SMART, did a report about similar location-based restrictions such as residency requirements. And they concluded in that report that there was no empirical support for them. And some of the studies that they based that conclusion off of found that overwhelming majorities of sex offenses and reoffenses, upwards of 80%, happen on private or residential properties. And for similar reasons, we believe that this type of legislation would not decrease recidivism. And the report also found that these types of restrictions can actually increase recidivism for some of the concerns that have already been named here today. By isolating these community members from their social groups and from their community, it can increase instability in them and lead to an increased risk of recidivism. And so we'd like to point out that this bill would prohibit parents and grandparents who are on the registry from picking up their children from school, from going to concerts, sports games, parent-teacher conferences, otherwise being involved in their children's or grandchildren's education, that it would prevent, as has already been mentioned, students from being at their schools if they're over 18 and on the registry, that it would prevent registrants from voting if their polling places were on local school property, It would prevent these community members from attending church services that are held on school property, which is common. And we'd also like to note for the committee that many people required to register had the length of their registration substantially changed by 2011 amendments to Kansas offender registration law. Many people's terms of years increased or went from terms of year registrations to lifetime. And if this legislation were to apply retroactively, this would be another significant change without process or individual assessment of risk. We ultimately just want to emphasize that these are members of our community. These are people who have served their time or were not sentenced to prison. The registry is wide-reaching. People register as sex offenders for things that are low-level felonies, misdemeanors, or even not sex offenses at all, like theft with a sexually motivated finding. People convicted of high-level offenses are sent to prison where they have long sentences and they're prevented from dispositional departures to probation. Ultimately, these registrants are members of our community, and it's in all of our best interest to support policies that promote rehabilitation. And we respectfully suggest that this policy does not do that. And we oppose this bill for these reasons, and I'll stand for questions at the appropriate time.
Thank you. Next, we will hear from Teresa Boutel, private citizen. Please introduce yourself and welcome to committee.
Thank you for your time today. I am Teresa Boutel. I am the state representative for Narsau. While all of us are concerned for the children, this legislation fails to keep them safe. It addresses a problem that does not exist at this time. After extensive search, there has been not one instance where a child was molested or randomly taken because a sex offender was on a school grounds. However, there's plentiful of cases of staff in schools abusing children, such as the one that's going on in Lawrence at this time. Virtually all sexual abuse children is committed by family members, peers, and trusted adults. The question that I want to ask today is who is standing up for the children whose parent is on the registry? Senate Bill 288 will devastate their lives. I have two things to say. 16-year-old Miles, he's up to be crowned homecoming king, and he would like his father to attend. But his father, with this bill, would not be able to attend to watch his son be crowned. Alex is a senior. He is going to graduate. His father is not going to be allowed to see him graduate. And even if he did, Alex is really scared of the booze, the stares, the remarks from other parents, and possibly his classmates. Studies document emotional trauma and stress, and anxiety and depression children with a parent on the registry feel anyway. This will make it worse. According to the book From Rage to Reason by Emily Horwitz, a professor, in social criminology justice at San Francisco College, says children with parents on the registry will suffer in profound ways. This bill will interfere with parents' rights to parent their children, thus making the state and the school districts vulnerable to legal challenges. Since last year, New York has been embroiled in an ACLU challenge concerning the state law that prohibits a person on the registry from being on school grounds. California schools right now have had several suits where parents are suing because they cannot be involved in their children's education. Parents with spouses, they are going to suffer this also because they will alone have to take their kids to band practice, activities, sports, and other activities at the school. This will worsen the problems for any spouse whose spouse is on the registry. This bill, it will do nothing to protect the children. This bill was actually started because of fear emotion, which is now got fear panic, which has caused fear media, and now we have a bill that is based on fear. I will be open to any questions afterwards. Thank you.
Thank you. Next, we will hear from Shirley Furley, a private citizen. Please Please introduce yourself and welcome to committee.
Madam Chair, I'm short. Madam Chairman and ladies and gentlemen, thank you for having me here. My name is Shirley Furley. I'm from Paola, Kansas. I speak against this bill. I begin with questions. Why? And where are the statistics? I know there's been, I would like copies of those and how they were obtained. But as far as the Blue Valley School District, has there been incidences of a sex offender problem? Or is this just a motion? As the news portrayed, how do you know the person who is the real offender at the dance is not Janie's father, who is not on the registry? That does happen and is happening. The statistics are not there. Approximately 95% or more of those on the registry are first-time offenders who will never commit another crime or another offense of the same type. Not only will it further punish registered citizens who are trying to move on with their lives as a law-abiding citizen because they have finished their terms, it will continue to punish his or her children, their grandchildren, as well as spouses, friends, and family. This bill will cause more harm than good. Statistically, if another crime is committed, it happens within the first 5 years. And by 10 years, it's very likely to happen. According to the Channel 41, I'm from the Kansas City area, the article on the man, said that it has happened in 2011. That was 14 years ago. Has he committed another crime? One of the many reasons to abandon this bill is because of Ted and others like Ted. Ted was 21 when he was at a party and had a relationship with a minor. The minor was not supposed to be at the party, should not have been there. And she never held any blame towards Ted. After the initial arrest, he was trying to cope with it with alcohol and drugs, and so that put him on the registry for life. That was over 25 years ago. He found love, a family, he has a family, and the most important thing is he's a very good father. I have something for the Judiciary Committee, but I'm not going to go in it. Just please look at page 26. It's the Penal Code, Article 213, page 26 to page 33, addressing the offenders. I implore you to banish SB 288. It is segregation, it is discrimination, it is hatred, and it is punishment, not based on fact. Thank you.
Thank you. Next, we will hear from Eldon Dillingham, private citizen. Please introduce yourself and welcome to committee.
Good morning. My name is Eldon Dillingham. I want to make the first speaker today announced to you that the rate of recidivism for sex offenders is high. That is absolutely based on criteria from research from SORNA, the Sex Offender Registration Notification Act group, from law schools, from psychologists. There's a tremendous amount of research out there that will counter that is absolutely not correct, what you heard. The lowest recidivism rate for individuals who were charged with an offense is murderers. That's the lowest. Secondly is sex offenders. So please, please, when you hear these things, do your research and make sure you're basing your information on accurate statistics. So you all have my written comments, and so I'm not going to go into those, but I'm going to tell a story about an individual. I've been involved in advocacy efforts various legal type things. For years and years and years, I work with a group of advocates who work with registered sex offenders. And so I asked an individual that I know to come here and speak today, and he chose not to. He's 30-some years old, has custody of his daughter, and is a wonderful, wonderful person, works hard. I read the bill to him, and he said, I would like to ask him some questions, but I'm not going to come because I'm going to get beat up. And, so he said, so I can no longer take my daughter to school in my truck and drop her off because I cannot go on the school property where the buses park and pick up kids and drop them off. So I have to drop my daughter off on the highway where the speed limit at that particular school is around 45 to 50, very busy. And I know I'm running out of time, but this bill has not been researched. This bill, there is so much that you should have done before you came up with this bill. And why you don't let the school districts do their weigh in, I don't know. There's 280 some school districts. I don't understand why you didn't do due diligence and study this bill rather than what you're doing to these individuals. And it's very harmful to these individuals. Thank you.
Thank you. Next, we will hear from Keith Weiner, private citizen, and he's on WebEx. Please introduce yourself and welcome to committee.
Thank you. My name is Keith Widener, and I oppose the bill. I'm a registered sex offender, and I understand the weight that such a label carries. It is something I will carry for the rest of my life, and I do not take lightly the mistakes I have made in the past. However, I am a father, and the most important thing in my life is raising my daughter to be a happy, healthy, and successful individual. Sorry. The purpose bill in Kansas, which seeks to restrict my ability to be near her school, poses a devastating threat to that mission as a single father. I am doing everything I can to ensure my daughter grows up in an environment full of love, support, and stability. I work endlessly to be the father she needs me to be, and I have made it my life's purpose to provide her with a safe, nurturing home. But the reality is that this bill will tear that apart. It is hard to put into words how much my daughter means to me. She is my heart. And every decision I make is for her future. If this bill is passed, it will essentially separate me from her world. I would no longer be able to be there with when she needs me the most. Whether it's attending her parent-teacher conferences, picking her up from school, or being present in her extracurricular activities, it all would make it impossible for me to maintain the day-to-day participation that is essential to her emotional well-being. This bill doesn't just punish me, it punishes my daughter as well. She would be denied the love. I'm running out of time. I understand that the law is created with the intent to protect the children, and I do not take the responsibility lightly. But I live.
1 minute remaining, sir.
I believe it is crucial to recognize the unique circumstances of individuals like myself. It takes time, work hard every day to better people. I ask for compassion and understanding in this matter. Please consider the impact this bill would have on families and specifically on my daughter, who has only one parent striving to give her everything she needs to succeed. Please think about the lasting harm this will do. Thank you.
Thank you. Next, we will hear from Galen Bauman, Just Future Project, also appearing on WebEx. Please introduce yourself and welcome to committee.
Chairwoman Warren, Vice Chair Titus, Ranking Member Corson. My name is Galen Boffman. I'm the Executive Director of Just Future Project. We are a national policy advocacy organization based in Washington, D.C. Just Future Project focuses on what I think of as the deep end of the criminal legal system. We specialize in systems of permanent punishment and perpetual parietum. We know that the worst abuses of state power are almost always visited upon the most marginalized people in our society. As the bill under consideration today by this committee clearly shows, that group is people living with a historical sex-related conviction. Keeping kids safe is a universal value, but SB 288 isn't designed to do that. This bill is a political overreaction to a news story. It is not a serious policy based on evidence. I listened to the proponents this morning, and I'm very sad that elected law enforcement officials in Kansas are offering bald-faced lies to this committee about the data of recidivism in this field. Allow me to review a few
Sir,
of those
let's
numbers.
keep the testimony to the bill, please.
I think it's pertinent to the bill, and I'm going to explain by painting pictures with those numbers. 95% of sex offenses are committed by somebody who's never been convicted of a sex-related crime in the past. These are, by definition, first-time offenses. 93% of sex-related crimes involving children are committed by a family member or a close friend, somebody known to the child, not a stranger. 92.3% of persons with a past sex-related conviction do not reoffend in a 9-year follow-up study by the Department of Justice in the United States, reflecting a 7.7% recidivism rate for sex crimes. The vast majority of people released after a sex-related conviction do not commit a new sex-related crime. Most new sex crimes are committed by somebody after leaving prison, are actually committed by the majority of the 3,800 or so people who walk out of Kansas DOC every year who were not imprisoned for a sex crime. SB 288 targets a group of people who are extremely unlikely to commit a sex offense involving a child at a place that they are least likely to commit that offense. SB 288 ignores, by definition, the vast majority of sex-related crimes against children. This committee is considering a form of vampire legislation.
Sir, 1 minute remaining.
Like Phantom Menaces of yore, we think to create special lands where evil cannot abide. This is a 2025 version of Vampires and Holy Ground. The label sex offender has talismanic powers. The term invites us to view the person as less than human and inspires proposals like SB 288 designed to banish people from our society, yet virtually no one branded with this toxic label is currently causing harm. Most will never cause harm again. Chairperson Warren, you told the press after the Blue Valley School Board meeting, quote, "Every legislature I have shared this story with has had a visceral reaction. It's just horror and disgust," close quote. I ask you to legislate from a place of rational analysis, not horror and disgust. This is a bill to placate angry parents. The children of Kansas need you to create evidence-based policies that would keep them safe. SB 288 does nothing of the sort. I refer you to my written submission testimony. Thank you.
Time's up. Thank you. Is there anyone else wishing to testify as opponent on the bill? Not seeing anyone. Then committee do also want to direct your attention to at your desk, you have opponent written testimony from Karen Logan-Bills, private citizen. And with that, we will open it up for any questions. Not seeing any. I do have a question. I want to go back for just a moment, if I could, to our neutral conferee from the Kansas Association of School Boards. Just a very narrow question, if I could, regarding IEP attendance practice currently in place, for instance, for parents who were imprisoned. Do we have Zoom capability to do that? Do our schools offer that? If you could reintroduce yourself too. And make sure your microphone's on. Thank you.
Pardon me. Thank you, Chair Warren, Shannon Kimball, Kansas Association of School Boards. So in the IEP process, usually notification is sent out to all of the parents or guardians on record. So in some cases, you can have an IEP meeting with one parent in attendance. I'm not personally aware of the kind of circumstance you're describing. I can say that in some districts, they do have capability to do some of these meetings virtually. I would hesitate to make that representation for every district. Certainly, post-pandemic, many more districts have access to those kinds of systems and supports than we would have pre-2020. But I can also try to find out some follow-up information for you on that particular question about incarcerated parents, because I don't personally have experience in that area.
Thank you. With that, then, I want to thank our conferees for coming today and for appearing, and we will close the hearing on Senate Bill 288. And I am going to have to step out for just a moment, but I'm going to ask our vice chair to open, and we'll conduct the hearing on House Bill 2359. Thank you.
Thank you, Madam Chair. If we could have the reviser please explain House Bill 2359.
Thank you, Mr. Chair. House Bill 2359 enacts the Uniform Adult Guardianship and Protective Proceedings Jurisdiction Act, and also the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Acts. The bill also makes some conforming amendments throughout the rest of the statute base to deal with the references to those acts. I'm going to be really brief, kind of like I was with the LLC update bill. You have the Judicial Council here who put the bill together. So sections 1 through 23 contain the Uniform Adult Guardianship and Protective Proceedings Jurisdiction Act. Sections 24 through 135 contain the Kansas Uniform Guardianship, Conservatorship, and Other Protective Arrangements Acts. And you can see which provisions there. Sections 51 through 63 concern guardianship of a minor. Sections 64 through 82 concern guardianships of adults. And then sections 83 through 118 concern conservatorships. Sections 119 through 130 concern other protective arrangements. It also provides some specificity about what types of proceedings all these acts would apply to. And then finally, sections 136 through 166 are those remaining statutes that just make references to the old acts that are being repealed. So those sections are amended to update those references. This bill is a little bit delayed. It would take effect on January 1st of 2026 if enacted. And I can take any questions.
Are there any questions for the reviser? If not, thank you. We'll begin with proponent testimony. I have two conferees listed for the Kansas Judicial Council. If you'd come forward and introduce yourself, please.
Good morning, Vice Chair and members of the committee. I'm Judge Marilyn Wilder from the 9th Judicial District, which is Harvey and McPherson counties. I chaired the Guardianship and Conservatorship Advisory Committee that was asked to study these bills. We began meeting in 2020, and the committee was made up or is made up of judges, lawyers, and social workers who practice in this area. When we began, there was some thought that the Kansas law was actually pretty good just the way it was, and as we worked through the Uniform Acts, saw that the Uniform had a lot to offer, and so we ended up infusing the Uniform Act with a lot of the elements of Kansas law that we thought were best. The Jurisdiction Act has been adopted by 46 states. It allows for very clear guidelines and procedures if a person subject to guardianship moves to another state so that that other state can take jurisdiction of the case. And so we definitely support that. We also are highly in support of our version of the Uniform Guardianship and Conservatorship and Other Protective Arrangements Act. At this point, the most recent data I had was from 2020. There were only 2 states that had adopted the act. I tried to find more up-to-date data and could not do that. And I'm actually not sure that our version of the law would qualify as uniform because we did change a number of things. The new legislation is very person-centered. At this point, somebody can have a guardianship established simply by a doctor writing a note that says this person needs a guardianship. The new act contains a more detailed evaluation as to what the person's needs and abilities are. The new act uses very person-centered language rather than referring to a ward or conservatee. We talk about a person subject to a guardianship or subject to a conservatorship. The act is better organized than our current Kansas statute. It's easier to read. And again, it's very person-focused. To take a spectrum from persons who have great needs and not to necessarily impose that on every person subject to a guardianship. And so there is a plan required in each case to determine what the person's needs are, the ways that they can participate, if at all, in decision-making and in making those plans. The new act provides greater requirements on the attorney appointing the person subject to guardianship or conservatorship, and we also now have an option for a court liaison. The Uniform Act required that in every case. We weren't sure that there were resources or those persons necessarily available, so we have it as permissive rather than required. We did open our proposal to feedback and received feedback and took that feedback and did make some changes to what we had originally proposed, and I will stand for questions when that's appropriate.
Thank you. We will go through all the in-person proponents, and then we'll have questions at the end.
Thank you.
Up next, the Disability Rights Center. Ms. Perner, are you going to? Okay.
I'm sorry. I apologize. And good morning to you. I'm with the Judicial Council, too. I'm kind of trailering on, I guess, piggybacking, but I'll make it quick. You've had a long morning. Rachel Perner. I'm in private practice in Wichita, Kansas. I practice with a Triplett Wolf and Garrettson firm, and I have handled well over 1,000 of these cases. I mean, whether it is minors under a legal impairment, minors with a legal impairment, adults with an impairment, this is all language under our existing law. And I've worked since the inception on this advisory committee to, almost 5 years get this done. But I do think that a part of the committee's thinking, the advisory committee, that is, when we sent it, is that our current law, which is about 25 years old, really is very black and white. It is a winner-take-all, loser-take-nothing sort of setup. So either you are adjudicated and you receive a guardian and a conservator, and those personal individual rights are taken away, or you don't. And so the biggest thing to me is that this provides for other protective arrangements for the court to order. And that can be any number of different things. And I want to give you just a couple of examples. I worked on a case about a year and a half ago for a guy that ran a very lucrative, multi-million-dollar business. And he had recently got divorced. He was an older gentleman, lonely, fell prey to romance scams to the tune of well in excess of $1 million. Now, this is a guy that's putting the deals together for the company. He is the president of the company. He is making some really lousy decisions in his personal life. And we ended up in a guardianship conservatorship, and that really did not suit him. I can't imagine anybody here would be terribly excited about investing $100,000 in some drilling operation with somebody that's subject to a conservatorship. What he needed was a very narrowly tailored legal remedy to keep him from falling for these romance scams. And there is nothing embedded in the law today that permits that. It is also very common. I worked with a lady that went in for, her sister had been badgering her about getting power of attorney. She had been diagnosed recently with a brain tumor. She didn't want to appoint her sister as a power of attorney. The hospital, of course, had to discharge her. They've got to get her to rehab, and she is incapable of consenting to that treatment. And so What the hospital does is they file, they've got to get an empty bed, they've got to get somebody with the legal authority to admit her to rehab. And she kind of recovers and figures out, well, the sister has taken over her life, has emptied her house, has sold personal possessions. And so I was a part of restoring her to capacity. But again, if the hospital needed to get her out, they could go in a very surgical way and empower someone to consent to that future treatment. The plan that the judge alluded to, 90 days out, a lot of times people end up situationally, they fall and break a hip, or they end up with a urinary tract infection. And so it is a transient state of mind. And you end up with this guardianship and conservatorship, and you can't get out from under it. Now, I want to turn just to a couple of examples with the Jurisdictional Act, which I know must sound terribly boring, even though some of you are lawyers and we make kind of the same noises. I think most of you have probably heard of child kidnapping, parental kidnapping. Well, the same thing goes on with our elder adults, all right? I mean, I've had mamas kidnapped to Missouri, I've had mamas kidnapped to Washington, and all of a sudden we end up with litigation in Washington, litigation in Kansas, litigation in Texas and Missouri, and there is no system amongst the states like there is with children for determining a logical way to determine which court should defer to who. And the other thing that this does, and I think we're only one of 3 or 4 states that don't have this right now. If I am representing a conservator for an individual that owns oil and gas interests in Oklahoma, and those oil and gas interests need to be sold, and I've got a Kansas conservatorship, I can get an order from a Kansas court. I can't enforce it in Oklahoma. This Jurisdictional Act, I have to go file a lawsuit in Oklahoma, driving up the cost for everybody, delaying everything for everyone. What this would do is open the door to full faith and credit for the management of assets so that one court is overseeing it and we are getting deferential treatment from our sister states. With that, I will be available for questions if you've got any at the appropriate time. Thank you for your service, your public service. I appreciate it. I'm sure there are some times you don't feel the love, but you got to know, I appreciate the system.
Thank you. Up next, the Disability Rights Center of Kansas.
Thank you. My name is Rocky Nichols, Executive Director of the Disability Rights Center. I'll hit the high points. We did provide extensive testimony for the needed details for this committee. We strongly support this bill because of the House adopted amendment which was jointly proposed by our agency, Kansans for Life, Kansas Catholic Conference, Kansas Council on Developmental Disabilities, and the Big Tent Coalition. And that amendment fixed the end-of-life guardianship issues. The full Judicial Council must have had some reservations about the end-of-life provisions contained in this bill prior to the House amendment, because that council specifically left this issue to the legislature to solve, which the House did. The House committee did that in its amendment. Time constraints were also an issue. The Judicial Council met in December, and as you know, the session started just 1 month later. Given the time constraints, having the full Judicial Council make changes on the fly during its December meeting was probably not advisable. Quite simply, death is different. With the House amendment, this bill now respects that. As amended, if a person with a guardian over them has a prior advance directive on end of life, that directive controls what happens. Also, this bill only applies to people with disabilities who have guardians, and it does not impact on the difficult end-of-life decisions that families must make for their loved ones when there is no court-appointed guardian. The version of the bill prior to the House amendment would have allowed a guardian to end the life of a person with a disability if they used artificial means like kidney dialysis, feeding tube, etc., if the treatment would not restore the adult's capabilities beyond what they currently possess. Under that problematic language, even people who are not at death's door and could continue to live for many, many more years could be put to death. Our testimony has 4 examples to highlight that. I'm going to cover just 3 of them. First case is a real-life example of someone who actually died from this fatally flawed language. A person with mental illness was living at Larned State Hospital, also required kidney dialysis. That's an artificial means. The guardian had 2 doctors certify in a petition that the person fit the fatally flawed language in the statute. The court approved the petition. A standing do not resuscitate order, or DNR, was issued. He discharged into a nursing home. The standing DNR followed him. He subsequently choked while eating. He was not resuscitated, and he died. The House amendment fixed that issue. The first one was a real example. The next one's hypothetical, but it illustrates this very real problem. Police officer is shot several times in the line of duty, suffers a spinal cord injury and bodily damage to where he eats with a feeding tube and breathes with a respirator. Both are artificial means. Police officer is not at death's door, he's not terminally ill, and he will not die imminently. Because the things that prolong his life are artificial means, and the treatment keeps him alive and stable, but it would not, quote unquote, restore the police officer to, quote, any significant degree of capabilities beyond those he currently possesses, under that flawed language of the bill prior to the House amendment, a guardian could end the life of that heroic police officer. I'll skip the 3rd example. The fourth example is not hypothetical as well. It's a real-life example of a Kansan with Down syndrome who would have died because he met that fatally flawed language of the law. The guardian told others that they wanted to withhold and withdraw medical care because the guardian was, quote, just tired of dealing with him being the person with Down syndrome. His friends made clear to the guardian that DRC was prepared to take legal action to protect the person's life. You should know, however, the DRC attorneys privately believed that the guardian would ultimately prevail in that legal action because of how flawed the language was. But thankfully, the specter of potential litigation caused the guardian to do the right thing and preserve the life of his ward. How the House amendment fixed the fatal flaws. There are now distinct provisions for withholding and withdrawing of food and water. Many people with disabilities get their food or water through artificial means, such as a feeding tube, like the example of the police officer. Death by withholding and withdrawing of water is often horrific, long, and a painful way to die. The House amendment provides sufficient protections in that regard. Before the House amendment, a guardian had broad powers to end the life of people who were no closer to dying than any of us in this room. The House amendment makes clear that regarding withholding and withdrawing of medical treatment, that 1, if the person with the disability had a prior directive pre-guardianship, then that directive controls what happens. And 2, that these end-of-life decisions would be limited to, quote, to when, quote, the adult is suffering from a severe illness and that life-sustaining medical care is objectively futile and would only prolong the dying process. We also included a top 20 list of the top 20 other positive pro-disability changes in this bill. There's tons of positive changes in this bill that do not concern end of life. But because we and our partners spent so much time on this issue, we've concentrated our testimony on that, and given the time constraints, I'll end there and stand for questions at the appropriate time.
Thank you. Up next, Kansans for Life.
Thank you, Mr. Vice Chair. I'm Jean Gowden with Kansans for Life, and just want to thank you for the opportunity to testify in support of 2359 with the House amendment. While we appreciate the hard work the Judicial Council, the Guardianship Committee did to update the guardianship statutes, our organization had originally been opposed to the bill as introduced due to what the previous conferee had talked about. Mr. Nichols, the concern over the language regarding the withholding or withdrawal of life-saving or life-sustaining medical care, treatment, services, or procedures. Back in 2007, Kansans for Life had supported legislation that would have corrected that particular area of the guardianship statute, and unfortunately that bill did not pass. So last year we came together, as Mr. Nichols said, with the Kansas Catholic Conference, Big Tent Coalition, Kansas Council on Disability, Developmental Disabilities, and the Disability Rights Center to be able to present our concerns to the Judicial Council's Guardianship Committee and offer suggestions for how to correct the flawed language. As Mr. Nichols also said, the Judicial Council ultimately did not endorse the problematic section of the Guardianship Committee's report and stated again that it was the purview of the legislature to develop the appropriate language. So that happened in the House. An amendment was supported by all of our organizations in the House Judiciary Committee, and it was added, and the bill passed the House. So we very strongly support 2359 with that House amendment, and we ask you to pass it out favorably, and I thank you for your consideration, and I'll stand for questions at the appropriate time.
Thank you. Next up, the U.S. Department of Defense via WebEx.
Are you able to hear me?
Yes, thank you. Please proceed.
Chairman and honorable members of the committee, the Department of Defense is grateful for the opportunity to support the policies reflected in this bill. My name is Michelle Richert. I'm the Midwest Region Liaison at the Department of Defense State Liaison Office. We operate under the direction of the Undersecretary of Defense, Personnel and Readiness. The policies reflected in this bill is it's a crucial piece of legislation that would bring much needed uniformity to guardianship laws in Kansas. This bill directly addresses the challenges faced by military families relocating to the state due to a permanent change of station orders or other mission requirements. Kansas is currently only one of 4 states not a party to the Uniform Adult Guardianship and Protective Proceedings Jurisdiction Act. This lack of uniformity places undue burdens on military families with adult dependents, forcing them to navigate a complex and costly legal process each time they relocate. The average military family moves every 2 to 3 years. This process not only consumes valuable time and financial resources, but it adds significant stress to an already demanding lifestyle. The policies reflected in this bill offer a streamlined solution by aligning Kansas with guardianship laws across the country. These widely adopted acts facilitate the seamless transfer of guardianship and related orders across state lines, eliminating redundant legal proceedings and easing the transition for military families. In closing, let me say that we are grateful for the tremendous effort that Kansas has historically given in supporting our service members and their families. And we would also like to thank you for the opportunity to comment on this important policy change. I stand by for any questions that you may have. Thank you.
Thank you. Is there anyone else that would like to testify in person as a proponent? Seeing none, committee, do you have any questions for the proponents of this bill? All right, seeing none, thank you for your testimony today. Is there anybody that would wish to testify as a neutral on this bill? Seeing none, we would move to the opponents and call the National Council on Severe Autism.
See if I got, okay. Good morning. Thank you, Vice Chair and members of the committee. I appreciate the opportunity to speak on behalf of those who are unable to protect or care for themselves. My name is Joan Kelly, and as co-guardians for an extremely challenging young man affected with profound autism, my husband and I have been advocating for the best interest and the civil rights of our grandson since he was diagnosed at age 2. Aiden is now 34 years old, and he continues to operate at the capacity level of a 3-year-old. The National Council on Severe Autism, of which I represent today, is one of several national organizations that advocate for profoundly affected individuals. The brief video submitted to the committee, embedded in my testimony, is worth 1,000 words. It reveals the behaviors that are complex and dangerous and very common among this particular subset of the DD population, and is the best way that we know of to share the realities that we face. We are very grateful for the hard work of the Kansas Judicial Council on this bill. Their work, however, relied heavily on the Uniform Law Commission, and whose perspective, quite frankly, lacks balance and is actually void of any input from guardians who have lifelong personal experience in the care of profoundly affected individuals. I brought 3 of those letters showing a span of a 15-year blatant disregard of our requests for a seat at the table, and I'd be happy to submit them to the committee should they wish to review them. Because the American Bar Association and other powerful entities showcase a few incidents of guardianship abuse is why we are concerned, and actually that longstanding pattern of blatantly ignoring us should give everyone in this room pause. They continue to actually exclude us. We are the stakeholders, ladies and gentlemen, who make the lifelong sacrificial investments in the care of those most in need of protection, and that's why I'm here today. I'm heartened that Chairman of the Judiciary Committee said that there's an easy way to doctor just signing guardianship. However, because we have been besmirched and ignored for these many years is why we are requesting an amendment to this proposed bill. The House Judiciary Committee stated recently there wasn't enough time to read all bills and rely on experts, and we are the experts who've been ignored, quite frankly. So we believe that if this bill is enacted as written, it could give opportunity to attorneys that might challenge us, because we've experienced challenges from those who have a less than honorable agenda and hold to an ideology that does not represent us. We would respectfully request the committee to, we think there'll be loopholes left without an amendment, and further risk our loved ones' safety into the hands of people with little or no experience in providing 24/7 care. And I'm referring to visitors and liaisons and attorneys that have no experience with our loved ones. So our respectful request in closing is that this bill be amended to insert further protective language that would honor the decision-making precedent that has been set forth in federal law, as noted below in my testimony. And thank you, and I'm happy to answer any questions at the appropriate time.
Thank you, Ms. Kelly. If you would sit tight for just a sec, is there anyone else that would like to offer opponent in-person testimony? Seeing none, committee, are there any questions for the opponents? Senator Shane.
Thank you, Mr. Vice Chair. Ms. Kelly, could I guess you elaborate or expound on what you see as the loopholes and what you would seek an amendment to accomplish related to those?
So the bill focuses on presumed capacity, and there's a lot of requirements to prove that we've tried other avenues, and to us, I'm not an attorney, but I can tell you that there appears to us to be possible loopholes of, well, these people really haven't tried, any other things. They're just overprotective and paternalistic. And those are things that are said about us and have commonly been said to besmirch us. Does that answer your question, Senator?
Yeah, I guess functionally I'm just trying to track what in the bill language potentially creates that as a potential worrisome loophole, and then I guess specifically the amendment. I think I understand what you're trying to say, but I'm functionally trying to understand how it might work within the
Yeah, and
proposed
I apologize that I'm not able to perhaps give a clear definition, but I will tell you that the fact that the Uniform Law Commission and the ABA have openly besmirched us, and they are indirectly trying to neutralize what is a precedent in federal law, and that is the quote that I have in my testimony, that that individuals with developmental disabilities and their families are the primary decision makers regarding services and supports. So we've been targeted as overprotective, and if we have to put our loved one in a intermediate care facility, for example, we are besmirched for that decision when we know firsthand that this individual needs 24/7 supports. So there are a number of entities that operate with unchecked that have really dishonored this, especially this section. And so we feel like not having an extra layer of protection clarifying that we are the primary decision makers, including and regarding choosing where individuals live from available options. This is in federal law. It's in the Disabilities Act. And we play decision-making roles in the policies and the programs, and yet often we are ignored even by some entities that were mentioned today. Is that helpful?
Yeah, I think what I hear you saying is that you would want to ensure that the statute gives primary deference to you as the families that are providing primary care, unless there's evidence to suggest that you should not have.
Yes, and that has been removed in most of the guardianship and protective laws that have been submitted in a number of states. I work with families nationwide, so we're very aware of being targeted and being kind of left out of this equation.
Okay, thank you. I think that provides clarity for me. Are there any other questions? Ms. Scott, given the cite to federal law, do you know offhand if that requirement for caregivers in the Disabilities Act would take precedence over any decisions in something like a guardianship or conservatorship decision?
Thank you, Mr. Chairman. I don't know that offhand. That would require me to do a little bit of research. Perhaps the folks with the Judicial Council who practice in this area might know, but I would have to do a little bit of research to find that out.
Thank you. I would draw a note then to proponent written only testimony from the Kansas Council on Developmental Disabilities, the Kansas Catholic Conference, the AARP Kansas, the Long-Term Care Ombudsman, and the Kansas Department of Children and Families. Is there anyone else that we missed that would wish to testify on this bill? Seeing none, we will close the hearing on House Bill 2359 and open the hearing on House Bill 2342. Ms. Scott, if you would explain it, please.
Thank you, Mr. Chairman. House Bill 2342 authorizes national criminal history record checks and state criminal history record checks for final applicants for certain sensitive positions within the Department of Commerce and for employees in those types of positions. New Section 1 would create a new section providing that the Secretary of Commerce may request the Kansas Bureau of Investigation to conduct a state and national criminal history record check on any final applicant or for an employee in a sensitive position within the department. A final applicant offered employment with the department in a sensitive position or an employee in a sensitive position shall not have a misdemeanor conviction for any crime involving theft, fraud, forgery, or other financial crime, or any felony conviction. The section also provides for definitions for final applicant and what a sensitive position would be. Section 2 amends KSA 224714. This is the statute that provides which records each agency is able to receive when they request a state and national criminal history record check. These particular criminal history record checks would be added to subsection B5, which means that the Secretary would be authorized to receive criminal history record information related to adult convictions, adult non-convictions, adult diversions, and juvenile adjudications. And I can take any questions.
Thank you, Ms. Scott. Any questions from the committee? Senator Reichman?
Thank you very much. I hated to ask it because of the amount of time, but I thought we've already passed a bill very similar to this in the Senate. How is this House bill different? Thank you.
Sure. Thank you, Mr. Chairman. Senator Reichman, you guys did have a bill about fingerprinting this year. It was Senate Bill 30. That was related to the Department of Labor and certain employees within the Department of Labor. This one is for the Department of Commerce.
Any further questions for the revisor? Seeing none, thank you, Ms. Scott. First up, Kansas Department of Commerce, proponent testimony.
Thank you, Vice Chairman, members of the committee. My name is Rachel Willis. I'm Director of Legislative Affairs for the Department of Commerce. So we're here testifying in support of HB 2342. And like the revisor said, it would provide the Secretary of Commerce the authority to conduct national criminal history background checks for final applicants and current employees in very specific positions within the agency. The bill defines what those sensitive positions are and what a final applicant is. Sensitive positions include those division directors, assistant secretaries, deputy secretaries, IT managers, chief counsel, grant or loan program managers, and any position then the secretary deems to involve significant financial management. And then the final applicant is defined in the bill as a person in a select group of applicants that are most qualified for these particular sensitive positions and whom the secretary may intend to give final consideration for employment. So this would be a new step in our hiring process that will mitigate legal risks, ensure safety and security, and promote safety for the state and ultimately a positive work environment. So I will stand for questions.
Thank you very much. Appreciate your testimony. Is there anyone else wishing to testify as proponent on the bill? Not seeing any, then committee, are there any questions? Senator Shane.
Maybe just one brief question or comment. I'm wondering, and maybe the revisers and legislative research can help with this, I'm wondering if we should broaden this so that it's applicable to almost any agency and not just Department of Commerce. I think it seems like a sensible piece of legislation.
That would probably be a policy decision for the legislature, and to open it up for criminal background checks for other agencies would be, I would think, a policy decision. So, any other questions? Not seeing any, then thank you very much. Appreciate it. Is there anyone wishing to testify as neutral or opponent on the bill? Not seeing any, then we'll close the hearing on House Bill 2342, and we are after the noon hour. Appreciate everyone's attention and appreciate our Vice Chair running committee. I had to step out for a few minutes, apologize. And we're not going to consider final action on bills today because we're past the noon hour. We don't like to have to work afternoon. So with that then, want to thank everyone for their attention and our conferees as well. And our meeting is adjourned.